The idea of putting me in the middle of two war crimes presentations is to try and lighten up the mood somewhat, but for those of you that have experience of extradition law, I'm probably not going to succeed in that at all. A fellow member of Chambers said over the lunch break that I should probably strike through where it says extradition law and put section 51 committal, because that's effectively what extradition within the European Arrest Warrant scheme has become. Looking at the Council Framework decision, I don't expect you to all read it, but it's a new simplified system. Effectively, it's a new simplified system of transfer. It's not necessarily an extradition process, as those of you that have had some experience of extradition hearings at the City of Westminster Magistrates Court will have experienced yourselves. One of the main concerns is that triviality is not a bar. This is an experience of some of the cases that I've been involved with. The first thing that I would say, my head of Chambers, when he introduced me this morning, said that I'm doing mostly defence work. I've done mostly prosecution work up until now. I'm venturing into defence work now to try and even my success rate out a little bit to make it fair. So these are some of the cases that I've dealt with quite recently. The first one on the top was actually reported by Radio 4 recently of some concern. I probably should have put in there that it was actually 24 bars of chocolate and a yoghurt that was actually I apologise for the confusion. The second case was my first defence case, and I can say with complete certainty that that was one of the most difficult experiences I've had in any legal setting in defending an extradition case. First of all, I wanted to argue that it wasn't an extradition offence, as it wasn't an offence recognised in this country. And again, for those of you that have been in front of District Judge Evans, you can imagine how successful that was. The second point was the fact that what I was trying to argue, here was a gentleman who had to be returned to Poland to serve a 12-month sentence for not keeping up with two payments on a €500 television that he purchased in 1997. I failed on that point as well. The next point that we tried to argue was that it was in breach of his human rights because he has 5 children. His wife is incapable of looking after the children, and 2 of those children, although adult children, are physically handicapped. The judge didn't accept that argument either, but we'll come back to that point afterwards. The third one was actually my first ever prosecution case with the CPS whilst I was doing the secondment. And I'm pleased to say that that's one of the few cases during my secondment that I lost. And this was because of the good sense used by the district judge, who accepted that it was a criminal offence in this country. And all the Act requires is that it is a criminal offence in this country. It does not have to be an imprisonable offence. It only has to be an imprisonable offence in the requesting state. That's an important distinction. The judge decided to disregard the strict wording of the Act and to consider an 18-month sentence for being drunk in charge of a bicycle, a 21-year-old, and his first offence was harsh to say the least, and wanted to find out if there was a way that we could dispose of this matter more fairly than through an extradition. Then you'll see a 2-year sentence for handling of a stolen gate. Now, being a fence and receiving a sentence of 2 years, again, quite harsh. There were a number of human rights points argued in that case, all that failed. The man has since been returned to serve his sentence. I believe that one was in the Czech Republic. The last one is probably the most severe case that I've ever had to deal with. This was a British citizen who was convicted in the Czech Republic for 18 grams of cannabis. His initial sentence was 18 months, which 1 month per gram seems slightly fairer than 1 year per gram. He was allowed to leave the country, and subsequently, after he left the Czech Republic, the prosecution appealed. The appeal was heard in his absence, and the court overturned the original sentence and imposed an 18-year sentence. The only reason he wasn't returned was because he had a mental breakdown and was sectioned into a mental health institution. That was the only reason he wasn't returned. So that's the opening summary of extradition, and here is what I would just like to quickly go through with you, and by all means interrupt and ask any questions as I'm going through it, if there's anything that you would like me to expand upon. First of all, my work. As I said earlier, my extradition work started when I was in Bosnia. I ran a number of extradition requests in war crimes cases and organised crime cases. So when I came to Chambers, that naturally led to doing a secondment with the CPS, as that is in effect the only way to be briefed by the CPS, and that is the easiest way to learn on your feet, and it is truly a baptism of fire. The interesting aspect of my work within the CPS is it's very much like being a solicitor and a barrister at the same time. I was required to manage 150 cases and also to prosecute the list 2 or 3 times a week. And then once I'd finished the secondment, which lasted for 7 months, I was then briefed to prosecute as counsel. I was fortunate, due to my experience in Bosnia, to be instructed in probably the biggest extradition case this year, which was the request from the Republic of Serbia for the former Bosnian President, Dr. Ganic. He was arrested in March as he was leaving the country. He is an honorary Don at the University of Buckinghamshire. He was arrested leaving the country on a war crimes indictment from Serbia. Now obviously this was a highly politicised case. It had all the hallmarks of the Pinochet case. In fact, the first person that Dr. Ganic called when he was arrested was Lady Thatcher's aide, as did Pinochet. The interesting part of this case, obviously, probably one of the most difficult aspects of the case, particularly if you ask our senior clerk, was the fact that the case started whilst I was still with the CPS, and I was instructed whilst with the CPS. If they had waited 3 days until I'd finished my secondment, then I would have been briefed by the prosecution, by the defence, which would have been a private brief, and obviously a lot more interesting for me as a defence barrister rather than prosecuting the case. Unfortunately, I was instructed by the prosecution, and I was one of 4 counsel to, and my job was primarily to advise on Bosnian, Serbian, and IC2I law and practice. For those of you that are aware of how the case ended, it ended in the summer of this year with a very strongly worded judgment by the senior district judge who, writing the judgment as his last case before he retired, held that the request was a political request and it was an abusive process. Dr. Ganic has subsequently been discharged and is now back in Bosnia. It's been very good for him politically because it's excelled him in the election process, which is currently ongoing, and has assisted his party in Bosnia in being re-elected, which they probably would not be had it not been for this case. I'm currently instructed in a number of cases involving the former Yugoslavia and surrounding countries due to my experience of that region. A number of Albanian requests, but primarily my work is with the European Arrest Warrant countries because that is the bulk of the work. 90%, I would say at least 90% of the work concerns Polish requests. For those of you that have followed the stories recently, approximately 3,000 people have been returned to Poland. there is a military plane that comes every 2 weeks to take them back. Okay. What I'd like to talk to you about now, focusing primarily on Part 1 cases, the EU countries, is the procedure that we're required to go through. And this is more the opportunities for you as solicitors to become involved in this process. Now, many of you may consider the extradition law to be fairly complex and not really an area that you would like to expand into. And at the risk of doing myself out of work, I'd like to say it's not that complicated. Certainly what you're required to know for the initial hearings, for the early stages, is not that complex, but you need to know the basics. I certainly encountered a lot of duty solicitors during my time at the CPS where they would frequently ask for guidance on extradition work because they literally have no experience of it. They are criminal duty solicitors, but they are then thrown into the court to deal with it, not necessarily at their own request. So the duty solicitor's role is primarily at the initial hearing. And the thing that you need to be aware of is that what is said during the initial hearing can dictate the progress of the case from there on. And so you need to be aware of these basic points. Now, the preliminary issues are all fairly straightforward. Looking at the Act, if you look at sections 4 and 7, these are the first 2 points that you really need to consider. Now, these are very basic points on identification of the requested person and whether that person has been produced as soon as practicable and whether that person has been served with a copy of the warrant upon arrest or shortly thereafter. Very few arguments on these sections succeed. You also have to be aware that even if you succeed arguing the preliminary issues under sections 4 and 7 of the Act, that person may be discharged, but that doesn't prevent the requesting authority from having that person rearrested either under the same warrant or under a reissued warrant. The thing that you need to be aware of when you're advising your clients on these points is, and this is something that you can only learn through experience, there are some EU states that are not permitted to reissue a warrant. So once it's been discharged, that's effectively the end of it. There are at least 4 EU countries that applies to.